when we are live. Okay, you should be good to go, Judge.
All right. Good afternoon and welcome to the Ethics Subcommittee Inquiry of Staff, Real Estate Client Referral to Law Partners Business. I'll begin with reading the ethics conflict statement. Members of the subcommittee are hereby advised of their duty under the State Government Ethics Act to avoid conflicts of interest and the appearance of conflict, and are instructed to refrain from participating in any matter coming before this subcommittee with respect to which there is a conflict of interest or the appearance thereof. Hearing none, I'd like to make just a brief statement regarding today's proceedings. We've got a three-part inquiry, and in the scenario, and I'll read it for those of you who don't have the benefit of it in front of you. Attorney A is a real estate lawyer and a partner with law firm X. Attorney B is also a real estate lawyer and a partner with law firm X. Attorney B owns financial interest in title company. Inquiry 1, I believe we've dealt with exhaustively at the last meeting, and I think it is important during this subcommittee meeting to address some of the more novel issues presented in inquiries 2 and 3. So I would like to read those to you and then encourage our discussion to focus on those issues. Inquiry 2 is Client Smith retained Attorney A for a real property closing transaction. May Attorney A recommend title company to Client Smith and prepare a title opinion for obtaining title insurance through title company, while Attorney B remains a partner at law firm X and retains a financial interest in title company. And then inquiry number 3, does the answer to inquiry 2 change if Attorney A is an associate with law firm X rather than a partner? We have many attendees at this meeting. In our waiting room, we have members of the subcommittee who I expect to participate, and at the last meeting we recognized some of the attendees as participants, and I expect to recognize the same. I do wish to limit participation from other attendees of the meeting, limited to just those that participated at the last subcommittee meeting, in order to keep this meeting manageable and to keep it brief. And I do expect it to last about an hour. At 3 o'clock, I'm going to have to log off and chair another subcommittee of the State Bar. Many of you have submitted comments and points of view. They are being heard. I know I've read them. Brian has read them, and you're not being silenced. There'll be opportunity for comment later in the process if the Ethics Committee does vote to publish in this inquiry. With that, I'm going to turn things over to Brian Oten, Ethics Counsel for the Bar.
Right, and Judge, thank you for that overview. So, for those of you that are joining us, we wanted to focus today's conversation on the imputation question. And I guess we spent a lot of time talking last meeting about inquiry number 1, whether or not basically in a single transaction can a single attorney have both hats of closing attorney and title agent with no other attorneys to rely upon or anything like that, just that singular sort of scenario. Of course, the North Carolina answer for decades has been no, that's a conflict of interest. We talked about legislation that exists out there that also seems to weigh in and maybe I would say coordinate or complement the North Carolina ethical or standard ethical opinion on that particular matter. And so I think that the subcommittee did not have any sort of appetite necessarily for changing that position. understanding, of course, that really the main thing that we were looking at was not necessarily to fully kind of wipe the slate clean and re-examine every single aspect of that question, but to look at this next question of the imputation of the conflict of interest. And I think this is where we see this question has come up from ethics staff perspective multiple times, where you have that scenario that's described in inquiries 2 and 3 of just, you are attorney A closing on a transaction, and attorney B is in your firm, is a partner, and they have a title insurance company, they have a title agency, whatever it might be, and the attorney A, the question being, can attorney A, in closing that deal for the client, closing that transaction, can they refer their client to attorney B and attorney B's title agency as a part of the just kind of the legal services that they're providing here? So looking at those things, we have seen, I think we've got other opinions out there that have talked about the personal interest that a lawyer experiences, the personal interest that serves as the conflict of interest with that financial interest, and whether or not that personal interest gets imputed to the other lawyers in the firm. Now, personal interests under Rule 1.10 generally are not imputed. I want to be really clear on that. That's something that you can see, again, we're talking about Rule 1.10 and 1.10a talks about personal interests. Basically, the general, I guess, maybe back up and restate that generally speaking, conflicts of interest that one lawyer experiences in a firm under Rule 1.7 or 1.9 do get imputed to the rest of the firm, unless that prohibition is based on a personal interest of the prohibited lawyer, and the prohibition does not present a significant risk of materially limiting the representation of the client by the remaining members in the firm. And so we have that question that's been posed, and I think staff they kind of have to recognize that some folks have called for advice on this particular question, whether or not the conflict is imputed from one attorney to the next in this scenario. And staff has kind of come back with different answers. And that's why we brought this to the ethics committee, namely that, yes, it's a personal interest conflict, and we have an opinion that talks about a lawyer whose spouse owns a title agency, and said that was a personal interest conflict, and the lawyer could not refer clients to their spouse's title agency. And so, referring it to your partner's title agency, is that a personal interest? I think, we've like we said, the opinions kind of describe this type of financial interest as a personal interest. However, is it a prohibition, or is it a personal interest that would actually present a significant risk of materially limiting the representation of the client by the remaining lawyers in the firm? So that's something that the subcommittee needs to dive into. To see in these scenarios, is it appropriate under the rules of professional conduct for a lawyer, or is it permissible for a lawyer in lawyer A's position closing on a transaction for a client to refer the client needing title insurance? Can that lawyer A refer the client to their partner's title agency for the procurement of that policy? So that's kind of the main focus today. Judge, I don't know if you want to kind of get some thoughts from subcommittee members, or how you want to kind of open it up, because certainly we don't profess to be the end all on opinions here. There's a reason why a lot of folks from across the state have joined us today to help us sort this issue out. So how would you like to proceed, Judge?
I'd like to turn it over to someone on the subcommittee to maybe kick things off regarding this issue of personal interests and imputed conflicts. Is anybody, and if there's nobody in the subcommittee, then we can open it up to some of the other participants. All right, any participant want to discuss that issue?
Did I just bore everyone to death with that discussion of imputation of conflicts? I mean,
No, Brian, as far as a comment to make, when I started looking back at and of course this may come a little bit later, but the idea of the spouse being it's non-waivable. You can't, no matter how many clients say, sure, no worries whatsoever. When I looked at that opinion, of course, that is subsequent to 2003. Any amendments that were made, that's more recent than that. And so that one tend to carry a good bit of weight for me. And I've been doing a lot of running, biking, and swimming lately, getting ready for a triathlon. And I've been doing a lot of thinking because I got a lot of time on my hands to do that. And I'm having a hard time getting that particular opinion out of my mind as far as something that would give us some guidance on this imputation issue. Because even though I understand that a spouse is different from a law partner, I swear sometimes you spend more time with your law partners than you do with your spouse. Um, it's kind of ridiculous. But that has caused me a little pause on thinking, okay, we can wash this away if it's someone who doesn't have a substantial interest, potentially ownership in the title firm. If we just pass it over to somebody who maybe does, I don't know. I can't job that and say, well, no, we can just waive that based upon the fact that we have a client saying, sure, no worries whatsoever. We don't really mind that you have that interest in the title company. Have you, I'm not sure if you were in place in dealing with this particular ethics opinion that happened in '09 with opinion 14. Is there any background on that that you can maybe give to the group to let us understand a little better how that came up with as a non-waivable?
Yeah, so I was not on the ethics or working with the ethics department. I was in the grievance department when that thing came around. So yeah, I was not I wasn't dealing with this particular inquiry. Um, and I certainly don't want to put somebody on the spot who does have some institutional knowledge that decided to join just to listen in, Nicole McLaughlin. But I don't know exactly what the discussion was. But I think this is one of those things that as far as the personal interest conflict, whenever there is, I think we have other opinions that talk about that personal interest conflict when you are dealing with that type of financial interest being where there's the heightened potential for some sort of material limitation on the representation. And I think it's particularly when looking at something like title insurance, as being in many cases, I know not all, but in many cases, a necessary component of the actual transaction of the service that's being provided by the lawyer. That was just too close of a relationship, and I think that was the reasoning there. I see Nicole has raised her hand, and I would love to hear. I'd love to have our true expert give us some
Yeah,
thoughts.
so thank you for recognizing me, Brian. I was just going to sit back here in the shadows and just listen. Um, but my recollection of that opinion at the time was because the assumption was that lawyer and wife share finances, and therefore the wife's title company succeeding in getting money would flow to the lawyer. And so that's why the committee decided that the personal conflict of interest would be imputed.
Mr. Benson.
Oops, sorry. So first, am I clear that issue number one is in your minds resolved, or is that you're just going to focus on two and three? Is that right?
Well, we haven't come to a decision on it, but we want to focus on two or three today
Okay.
since we
Okay.
focused so exhaustively on issue
Got
one
it.
last time.
Well, I guess my quick reaction is on the imputation. I'm glad you brought up the spouse thing because that's exactly where I would have gone. Is to my mind, the relationships are analogous. They're obviously not the same, but to Nicole's comment of a moment ago, just like a husband and wife are going to share finances, so too will two law partners. And in my mind, there's really no difference between number one, number two, and number three in terms of the opening for harm to the consumer. They're really the same. They're really the same thing on a practical basis. And the closeness of the relationship between law partners is one that's going to cause the same kind of problems I think that a spousal relationship would have. I think it's virtually the same problems would exist in the case of a spouse, in the case of a law partner. I think it's very closely analogous. And, I'd point out too that, you have among the materials that you have is, for lack of a better term, kind of a thought leader memo from the leadership in the real estate bar that likewise would suggest that the answers to 2 and 3 should also be no, and not simply number 1, that they're kind of equal in their potential for harm. I mean, in the context of a law partnership, it really almost is like a sham setup where one partner owns the title agency, the other partner does the closings, and then they just shuffle money around between themselves to kind of settle up. In my mind, it really is in some ways even more problematic.
Amy Richardson.
Thank you so much. I mean, Brian knows this. I'm excited to talk about imputation just because it's something I think about a lot. Like, Brian gave me a smile. 2 things I want to make sure I make as points. Number 1, I guess I would almost call this legislative history. When I have looked at that 2010 FEO 13 opinion, one of the things I've noticed about it is it looks like there was an informal opinion that was very similar, and that the switch to a formal opinion, there wasn't a lot of change. So Brian and Nicole, you can fact check me on that, but that is my understanding. And in particular, that informal opinion occurred before the changes to Rule 1.8. And then there's no real analysis. I think maybe because the committee didn't feel it was necessary, given that it was a husband and wife, to do the 1.8 analysis. And I would hope the subcommittee doesn't lose the connection between the imputation issue and some of the 1.8 issues, in that under 1.8, there are required disclosures. So it's not just like when I'm teaching my students at Duke about imputation, I always use the example of like, I am not suing my mom because I am scared of my mom. My law partner can, right? And my fear of suing my mother doesn't impute to my partner, right? But there's no real disclosure necessarily required there. Sometimes there is, sometimes there's not. But 1.8 is saying that there would be disclosure required, at least under my understanding of the rules. The other thing I would say to the point about the partners, in imputations, if your partner takes the money, most of the time, unless there's some type of walling for a particular reason, like it may be the money does flow, and it's also assuming a lot about how partners share money. What if someone's a non-equity partner? What if they have a guaranteed salary? What about staff? That's the reason that the rules are very careful about this imputation issue. Not all law firms are the same, nor do we require them to be under the ethics rules. So thank you, Judge Langen, for the time.
Yes, ma'am. Anybody else want to address that?
I think it's an interesting question to me, but I think it is important to keep in context in the operation of a firm. And Nathan's a partner. He's driving policies on how these basically the entire closing process is going, right? And in that process, as the leader, you are able to set policies that are going to impact your partners, certainly will impact your associates, right? Decisions between conducting a full search, in which case you're going to obtain a full title insurance premium, relying on prior policies where you might obtain a discount on behalf of your client, obtaining enhanced title insurance policies, which are a buzzword right now in industry. Fundamentally, the person conducting the closings, the decisions they make are going to impact the title premium received. So I think that it's hard for me to distinguish, even in that partner role, and certainly more certainly in the associate role, how the financial implications for the whichever individual has that ownership interest in the title company is not driven by firm policy about how these closings are conducted. And I think it can be very coercive, especially at the associate level. I think it's still coercive at the partner level, because everybody's got to feel like their effort is rewarded. But
Mr. Zaleski, your name was mentioned, so you get to respond like in the political debates when they
let me unmute there. So my name is Nathan Zaleski. I am a real estate attorney. I've been practicing for 23 years in real estate. I own Sterling Law, and I also own Sterling Title, which is a North Carolina title insurance agency. I think what's really important to note here is that um, we, back in 2017, through Ethics Council, approached the bar on this very question, and we received that the answer was yes, you can do it. And so we've taken that opinion, and obviously I have relied upon that opinion for years. I have built my business. I have invested my life savings into the business, and we have operated without issue under that opinion. So the answer from the ethics staff has been yes, and it has been provided to us in an informal opinion. I don't think that it's fair that there's attorneys like me that have obtained a private opinion from the bar that authorizes it. I mean, clearly this should be allowed by all closing attorneys. I mean, if you look at what the ethics opinions have been since 2003, in 2010 FEO 13, the ethics committee said estate planning attorneys can sell life insurance to their clients. In 2014 FEO 10, the ethics committee said that family law attorneys, when handling adoptions, can refer their clients to the lawyer's for-profit agency. And so what's really happening is you have updates in rules, and then you have to have updates in the opinions. And we haven't ever really had an update in any of the ethics opinions around title insurance following the 2003 update. So what really the task for the committee is more of a mundane administrative matter, just to simply update the opinions in accordance with the update to the rules, which is of course to allow the practice with disclosure and consent to the client. Of course, the client does need to be disclosed of this matter. Absolutely. Thank you.
Mr. Zaleski, just to be sure that I'm understanding I know you called in and maybe had received the previous answer a couple of years ago and set up your business. I want to be sure I'm understanding your business. Are you saying that when you do a closing, do you refer your clients to your title agency?
I personally don't conduct closings anymore,
Okay.
but so the answer is it's a not doesn't really it's a non-issue. However, the answer under the ethics rules is with disclosure to the client, I could, of course, I could.
Okay, I need to ask for clarification there because I thought last time. Well, I remember talking about this with you that we're talking about a single attorney. You are the closing attorney. And I thought maybe I misunderstood you or I'm just not remember correctly. If you're the closing attorney, can you refer your client, if you were in a solo practice, no other attorneys, can you refer your clients to your title agency? Just as you're wearing both hats in one transaction.
So that raises a 1.7 question.
Yes.
Which is a conflict of interest. And then, of course, you also have a Rule 1.8 question. And under both rules, the conflict is waivable. But so their answer is yes, you can. We also dived into the title insurance statutes, which I think was a big reason why the title insurance industry has argued that there is a prohibition. They're saying, oh, it exists in the title insurance statutes under Chapter 58. I detailed in the brief that I submitted to the committee that, in fact, there is no conflict created in the title insurance statutes, which of course are for the Bureau, the Department of Insurance, not the state bar. And of course, under the title insurance statutes, 5827.5, there is the express authorization to act as a closing attorney to provide services and receive title insurance premium so long as you receive it based upon a return of your ownership. And so basically the statutes provide that it can be done. Of course, the bar can overlay ethics rules and should overlay ethics rules that would require disclosure and informed consent. Those aren't in doubt. But the answer to the question is under Rule 1.7 and Rule 1.8, yes, that attorney can do that.
So I guess it's fair to say you disagree with the opinions that say that it is a conflict of interest under 1.7.
Well, there has not been an opinion since 2003 to say that, Brian. So
I understand 1.8 came out after
disagree with.
2003, but 1.7 remains the conflict of interest. I imagine you're not saying
But
1.8 allows you to engage in any financial transaction you want, regardless of whether there's a material limitation on your potential representation. They
well,
coexist.
I don't agree that there's a material representation on the representation. I mean, if you look across the country, and every state allows this practically, and of course the American Bar Association, which is, by the way, Mr. Benson mentioned that there was a thought leader memo that he put forward. The thought leader on this issue is the American Bar Association. They are the ones that come up with the model rules. Those model rules are adopted by North Carolina as well as states all the way, all across the country. And since for the past 60 years, the American Bar Association has said, yes, with disclosure to the client, you can go ahead and act as a closing attorney and issue the title insurance and in both rules. So that is the thought that should be guiding the committee's analysis.
And that opinion was under the Code of Professional Responsibility.
It was from the 1970s,
70s?
I believe.
It
And
was.
it's still good law today. And the CPR was more restrictive than what we have today under Rule 1.8.
I just want to I'm trying to measure out your statements about what is and is not good ethics opinion based upon timing and different versions of the rule. So I want to
Well,
make
there
sure.
has not been a single actual formal in-depth analysis of closings and title insurance after 2003. So this would be the first time that it's actually been looked at.
Mr. Benson,
So
are you still?
Yeah, I mean, 1.7 and 1.8 clearly do not allow, to Brian's point, any activity between the clients to be permitted after the 2003 change. I mean, there are serious restrictions on what would be appropriate in 1.7 and 1.8, and we have seen that since then. The spouse thing is, if you look at the language in the spousal, if you look at the actual language, it's very supportive of maintaining the status quo position. Look at it talks about when it makes its ruling, it goes on to say in justifying it that this is consistent with the emphasis that the North Carolina legislature has placed on the professional and financial independence of the closing lawyer from the title agency. So it's very clearly, that's a rule, that's a opinion that postdates the 2003 change and says that one of the reasons that it's making its ruling is because it supports the principle that's been in place since the mid-70s of a separation between the closing attorney and the title agency. And the comment that was just made, it wasn't the bar, the leadership of the real estate bar is very concerned about this. There were 24 people who signed on to that memo, including the chair, the vice chair, the secretary treasury, 8 prior chairs of the section, the president of RELANC, the president-elect of RELANC, several council members. The leadership in the real property section does not want the change, feels that the change is inappropriate, and that any answer yes on 1, 2, or 3 are equally as problematic. I don't know what it strikes me that it's odd that we're talking about this when it's clear that the customer suffers, the client, ultimate home buyer will be harmed by a change in the system. The only person who in theory could benefit is attorneys, and they don't want the change. I mean, there's a minority that does, but the majority, the thought leaders, the leadership of whatever you want to call it, do not want the change. So I just, that came up in Mr. Zaleski's comment a minute ago. I thought it was appropriate to mention. And
I see Mr. Wall and Mr. Partone have their hands up, and I may have misled you, Mr. Wall, when I said you could attend and participate. You're definitely welcome to attend. However, Mr. Oaten had denied any participation from folks who were not at the last meeting or who were not participants at the last meeting in an effort to be consistent. Unless Brian wants to make exceptions, I think we need to limit the discussion.
I think it's up to you, Judge, as to whether or not I don't know what other folks want to offer or any other perspective, really.
Well, let's see. We don't
I
have
don't know
that
if the
many, we don't have
subcommittee.
as many people on this time as we did last time, and we're only a half hour into it. So if Mr. Wall wants to say something, keep it under 60 seconds.
Yes, thank you, Judge Langdon, and I will keep this quick. I just wanted, I felt it important to participate today because I felt like I did provide a somewhat unique perspective in that my background and experience having practiced in different jurisdictions that take a different approach to this. And really the main issue I wanted to touch on today was an issue that Mr. Benson just mentioned regarding the consumer protection aspect of this issue. In practicing in other jurisdictions, I can tell you that based on my experience, I could not disagree more with the statement that the consumer would be harmed by this, because in my experience, um, a change to this would benefit the consumer by having an additional attorney involvement in the process. So again, I appreciate you allowing me an opportunity to participate, and I will continue to watch the remainder of the hearing.
Thank you, Mr. Wall. Ms. Williams?
Thank you. So as discussed previously, and Jeff touched on this as well. So RELANC is the Real Estate Lawyers Association of North Carolina. As a board yesterday, as one of the primary industry groups for real estate practitioners in the state of North Carolina, and being that this is an ethics inquiry for the practice in the state of North Carolina that is applicable as leadership is related to that, they did take an official position on this as well, that to say yes to any of these inquiries would be harmful, not only in perception, but in actuality for consumers. Even if it is determined to be potentially a waivable conflict, which I don't agree that it is, the amount of time that would be needed to actually have an informed consent and disclosure to the average consumer is not available in residential closings. In most of these, we're looking at a 30-day close, sometimes less, depending on whether or not there's a lender involved. The amount of time it has taken, I mean, this has been obviously in discussion now since April, being referred to the subcommittee with highly educated, very well-respected attorneys that have experience across the board. Imagine the average consumer trying to understand all the ins and outs of this and actually be able to make an informed decision with enough time. Now, whether that means that they're having to switch closing attorneys, which also is unlikely depending on their timing and even getting that disclosure sent to them, it's not going to be a viable option for that area of practice specifically.
Amy Richardson?
And I have to say, I think Miss Brocker has been trying to raise her hand, actually, not virtually. So I'm happy to defer because I feel bad that I've spoken twice now, if that's helpful, and she is not.
All right, Ms.
And other
Brocker.
people. So I will cede since I've already spoken, Judge.
All right, Ms. Richardson yields to you.
Sorry, I couldn't figure out how to raise my hand online. I was just sort of, so I appreciate it.
Deanna, I can't hear her. Can other people hear her? Okay, good. It's not just me.
Oh, hold on. Hold on.
Deanna, it's just very light. It's like you sound very far away.
Oh, let me see if I can. Is any of that helping?
I was gonna see if it's connecting to your the right microphone. If you hit the little caret next to the microphone button, I wonder if it's switched to something else.
Anything? Is this better?
It's not.
Okay, hold on. Well, let me keep trying and see. I can't.
If you want to log out and log back in, we'll let you back in. Sometimes that's the magic.
Okay.
Mr. Portone?
Yeah, I want to introduce myself. My name is Dan Portone. I'm a partner here in Charlotte with Galbraith Costner. We are a real estate firm, primarily residential closings, some commercial as well. I want to push back a little bit on the vocal minority in that we've we've been working to circulate a letter. I know that you are aware of that, we've gotten well over 100 attorneys to sign off on in support of it's really inquiry number one, backing up onto that. So I do think that there's much more of a split in the practice than is being presented here. So just want to point that out as something, my contribution for now. And I am not an ethics attorney, so the imputation and all of that, I have less to speak on today.
Mr. Rosario?
Hi, everyone. Thank you, Judge, for letting me speak. My name is Rich Rosario. I operate a number of different companies, but essentially a title company and law firm that practices either through an insurance license or through a law license over 11 different jurisdictions on the East Coast. I just want to push back a little bit on Ms. Williams' discussion around it being impossible for a client to comprehend the conflict that is articulated in the North Carolina ethics rules from an individual owning both the law firm that handles the closing and the title company that issues the insurance policy guaranteeing that opinion. Our firm's closed well over 100,000 real estate transactions, and I can say without certainty that it is not beyond any of those individuals' comprehension to understand that the attorney who's actually doing the legal work and examining title pursuant to North Carolina law is incapable of, at the same time, assuring and ensuring that that person has title to the property on which they're conveying. So that fact, I don't think is all that complicated of an individual or a consumer to understand. And moreover, I think if anyone is going to underwrite an individual transaction, the person who is best situated to guarantee that the insurance policy actually issued is the attorney who's actually transacting the real estate. So just wanted to make that point, and I appreciate everyone's time.
Does anyone want to answer to that point? Because it would seem that the interests coincide. I know, Brian, you might have an example of when they wouldn't coincide, but I see that as one of the strongest arguments to support that position.
I can take that up. Kyle Smalling here. Again, I think I hinted at it earlier, but very quickly in the conversation. So fundamentally, right, a client is benefited by having a good title insurance policy with not a multitude of exceptions and certainly without a great deal of general exceptions in it. However, the cost of that policy is directly driven by certain decisions the attorney rendering the opinion is going to make, right? The decision to do an expansive search versus relying on a prior policy, right? If there's a prior title insurance policy within a certain period of time, using that reduces the scope of an attorney's professional search and potentially provides a client with title insurance premium discounts depending on the age and value of the policy. There also, again, is emerging options in the context of standard title insurance policies versus enhanced title insurance policies. And so from a client perspective, right, the decisions that attorney is making, which are not transparent to them, right? These clients are not going to be aware of the duration of the search, absent full advice, and a rep agreement can answer some of that, but not all of it effectively. But what the attorney does is going to impact the premium that is paid, which will impact the bottom line for the client. And if that attorney has a direct or indirect interest in the title insurance company, certain decisions, avoiding prior policy discounts, steering toward enhanced policies when they may not be particularly useful, sometimes they are, directly harm the consumer. And so I think there is a direct financial conflict there because the decision of the attorney and how they conduct that search will impact the premium paid in that matter. I also have a small concern about legal deserts, which may be a little outside the scope, and I know we're already at 40 minutes. But if you want to hear it, let's say I'm a small firm, right? I may, my firm, Capital City Law, probably right on the line of being financially viable for us to open a title insurance company alongside us. Many metropolitan firms, several of them are on the call, certainly can afford the additional overhead cost to have a companion title insurance company. What that allows you to do is reduce your attorney fee due to the recapture on title insurance premiums, which is fine. It's a discount for the client, right? Your attorney fee is less. That, however, does not apply to every real estate attorney in the state. And as you get smaller and as you get farther away, where volume is lower, there are going to be many attorneys that cannot compete in this market with title insurance. And when that happens, they're still going to have to compete on fees. And I know a lot of attorneys that real estate's kind of a nice keep the lights on, right, in rural parts of the state. And if they are not able to do that effectively, then they're not going to be able to stay open. And there may be a legal desert issue, which is fairly hypothetical, but it's something that I have thought about in the context of this decision. Thank you for your time.
Ms. Hunt, did you want to say something?
I do, thank you. And I'm one of those new to this meeting, so thank you for letting me speak, even though I wasn't here last time. Discussing the responsibility to the public, which is of course our bar's core responsibility, and how there can be a conflict there. My practice, just by way of background, I'm a dirt litigator. I'm a real estate litigator. I do title insurance claim work, both in North Carolina and South Carolina, which of course is the other system. I also defend real estate attorneys in malpractice claims in both North and South Carolina. I have no financial incentive at all related to this. I'm never going to run a title insurance company, and I don't do real estate closings. But I thought it might be helpful to share what I see on the other side of that, what I see when claims do pop up or what I see in malpractice claims. And the problem is the attorney is often trying to negotiate with the underwriter to get additional things covered. So they're advocating while the underwriter has to make the risk determination as to what the company's willing to do. If both of those are in the same hat, how does that decision get made? And I don't think a clear disclosure can be made to the average client. I don't think the average client understands that risk of exposure. And I don't think the average client understands what's in their title insurance policy until they have a claim, and then they have to figure it out. I worry about what that means in terms of claims, malpractice claims against real estate attorneys. Either you made the decision to get additional items covered, and now there is a claim against the policy and it is covered, or you didn't. And if you didn't, was it malpractice to not get it covered, or was it an underwriting decision that was properly explained to the client? And I think it really, having defended attorneys in South Carolina, I think it is a muddy, muddy area that speaks to the intermingling of these issues if the same party is doing both. So if anybody has any questions about what I see on the claim side or the malpractice side, I'm happy to chime in. But I do think coming at it from that perspective, it's pretty clear to me the problems that would arise.
Deanna Brocker, you're back on, able to speak.
Okay, can anyone hear me?
Yes, ma'am.
Lovely. Okay. Thank you for your patience. And I'm going to start it. I'm going to keep it short, but I've got a few points that I want to make. And then if anybody has any questions. So just to introduce to those of you who don't know who I am, my name is Deanna Brocker. I've represented lawyers in ethics and disciplinary matters since 2006. Before that, I was assistant ethics counsel to the state bar for over 10 years. I did do sort of regulatory compliance issues before that in private practice, but at least for the last almost 30 years of my career, I focused on legal ethics and the study of legal ethics. And I wrote to Brian after the last subcommittee meeting because about some concerns that I had, I wanted to share, and I just want to touch on the highlights of those. I'm not going to reiterate everything. But first, a little bit of background about why I'm interested and why I'm here. Of course, I have, as you know, I've represented Mr. Nathan Zaleski for a long time. I assisted him in getting the informal ethics opinion that he obtained from the state bar back in 2017 on the issue of whether another lawyer in Mr. Zaleski's law firm may refer business to Mr. Zaleski's title company. And since that time, I have assisted other clients as well in obtaining formal ethics opinions, and I have relied upon those same ethics opinions in giving my own clients ethics advice in this area. All of my clients received similar opinions from the state bar staff, permitting other lawyers in a law firm to recommend their law partner's title company under certain conditions with specific disclosures. I think both Suzanne and Nicole have given, thoughtful, well-reasoned opinions considering the post 2003 rule changes, and I believe they reached the right result under the ethics rules. But first, I would like to ask the subcommittee to really kind of focus on a rules-driven analysis first. Analyze the imputation of conflict issues, the law-related business referral conflict issues under the applicable rules first. Rule 1.7, 1.8A and J, 1.10A, 5.7, especially in light of the 2003 changes to those rules that permitted lawyers to have expanded business relationships with clients with certain restrictions and client-focused protections in particular. In my experience, focusing on the result that you want to achieve first and then trying to make the rules fit that has led to some inconsistencies in the ethics opinions, especially relative to the title opinions. And at some point, I don't have time to go into that, I don't think today, unless somebody wants me to, but I think that may be something that the committee ought to consider at some point. Second, I think that having the lawyers involved on both sides in the ancillary business and in the legal aspects can benefit clients and does benefit clients. And I think that the reason why lawyers are permitted to refer clients to their own law-related or ancillary businesses under the rules is the recognition that in many instances, having lawyers stay involved and handle law-related activities, especially when those services turn upon legal issues, are very close related. I think that's very much in the client's best interest, because in providing those ancillary business services, lawyers still have duties, often imposed by the ethics rules, to be fair, to be truthful, to be forthcoming, client-focused, etc. But I also think that there can be more practical benefits to clients in having lawyers providing those ancillary services. There's efficiencies, seamlessness, enhanced communications, a greater value in the totality of the services that they're providing. And of course, in the case of title insurance, there's no lost title premium check in the mail, right? So Nathan doesn't have to worry about that aspect. Finally, and this is my last thing I'm going to say, I believe an analysis of the current rules will lead to the conclusion that the rules of professional conduct would permit lawyers to refer clients to their own businesses under certain conditions. Rules also permit other lawyers in the owner lawyer's law firm to make referrals to that business as well under certain conditions, and that includes that aspect includes lawyer-owned title companies. I think this has been permitted for many years, and lawyers, my clients, have relied upon staff opinions in setting up their ancillary businesses. And I would just ask the subcommittee to consider rendering an opinion consistent with the informal opinions staff have given over the years and the rules of professional conduct. That's it.
Mr. Zaleski.
Thank you, Dana. I wanted to just kind of address some of the matters that Mr. Smalling had raised. First off, I do agree with Mr. Smalling's analysis that because the title insurance revenue could be captured, that would result in a decrease in fees to the client. So thank you for acknowledging that, and I do agree. That is a huge benefit. I mean, there is no greater benefit to the public than reduced fees, especially as crushed everyone is with bills these days. But more importantly, I want to address his other concern that, well, small town lawyers aren't going to be able to do this. I've set up a title insurance company in North Carolina, and I will tell you, it was like about $100 filing fee, and I had to fill out a piece of paper and send it into the Department of Insurance to get a license. It was very easy because lawyers are automatically vetted. to get these title insurance licenses. So there's no reason why any small town lawyer would not be able to go ahead and set that up. And I'm sure that there are just tons of underwriters out there. There are many underwriters now that would be happy to go ahead and back these small town lawyers. So I have no doubt that this would be available not only to the big firms in the big cities, but to the small town lawyers on Main Street as well. The last thing I want to address, and that is we haven't really kind of addressed the gorilla in the room, which is, what is a large part of the resistance coming from? Obviously, investors' title, it has been the primary driver for resistance to this idea. In the title insurance world, there is direct business and there's agency business. Direct business is what a title insurance underwriter, they issue the policy directly, they get 100% of the premium. If the policy is issued through one of their agents, that title insurance agency is going to keep about 80% of the premium, reducing the net to the title underwriter. It goes from 100% to 20%. And so, if you look at the Triangle Business Journal, they report that investors' title got over $60 million, 64, I think, million dollars in gross revenues. If that was direct business converted to agency business, that would be like a $50 million loss in revenue in 1 year. I'm not saying those are the exact numbers because I don't know, they're not publicly available, but clearly the amount of money that insurance industry could lose, which would ultimately go back to the attorney-owned agencies, is large. And we have to go ahead and just keep that in mind. But that is not a legal ethics issue, and the fact that that money is lost by the title insurance underwriters should not guide or influence the analysis of the committee. Thank you.
I'm sorry, Judge, can I just make a quick comment? I want to be clear to
Yes.
everybody watching and everybody on this call. As far as what the State Bar is concerned about, I'm a nerd, Nathan. I don't care if the insurance company loses money. All
That's
right, Mr.
wonderful.
Benson,
That's wonderful.
anybody else here? I don't care. What I care about is whether or not the rules are structured in a way that protects the public. The thing that I guess I have to recognize here, this is a really messy, sticky issue. And I think the thing that I keep on mulling in my mind, just noting that, like, we do have ethics opinions that say an estate planner can refer clients to their financial planning. Is that different? And I think some people would say yes, some people will say no. I understand the no, where you would say no, that's not different. I think it could be different in the sense that, when you write a will and you say, hey, by the way, in terms of you're planning for your estate, you're planning for your future. Well, I also offer financial planning services, as opposed to, hey, you're closing a transaction. You've retained me to close on this property, to acquire this property. I'm required by your lender to get title insurance, and that's a necessary component of that. And by the way, I'm just going to go ahead and refer you to my own company, which usually, and correct me if I'm wrong, I was not a real estate practitioner, so correct me if I'm wrong, but it's my understanding that generally the selection of title insurance, the title agency you go to, is delegated to the lawyer. I know that a client could say, I would like to go with investors, I'd like to go with Chicago, whatever it is. But I guess my understanding of the common practice is that clients expect the lawyer to make that selection in their best interest. And I think the thing that I get torn on is that situation. Like I said, I don't know all the different scenarios, but the nerdy question in my head is, if lawyer is trying to close on a transaction and they send something over, they're being the title agent too, there's something going on with the underwriter, the notion of pushback, and trying to say, oh, I want something covered further, less, whatever it might be. And it comes to the point where maybe not even because of the title insurance, but lawyer looks at the transaction and says, I really cannot advise my client to proceed with this closing. There's a problem with the title. There's a problem with the underlying transaction. There's something going weird with the sellers, whatever it might be. The question is, if a lawyer says, I don't think it's in my client's best interest to close, but now I have this financial interest in obtaining the financial benefit of this title insurance, is that something that materially limits their I guess their conduct. And I know, it's to be clear, there's always some sort of potential limitation in any lawyer's decision. I get that, but I think that's where this one, in looking at a 1.7 issue, a pure 1.7 personal interest conflict, do I have some sort of external interest that is influencing my decision to say, client, it's in your best interest to walk away? That's the nerdy question that I'm concerned about as an employee for the state bar. And I guess I just want to make it clear, when you say the big resistance is the title insurance company, I just don't care about people's pocketbooks. I care about the ethics of the issue.
All right, we've got 5 hands up and the discussion is getting very animated. I'm going to be withdrawing and I'm going to hand the gavel over to Mr. Scott, Martin Scott, who's agreed to chair the meeting in my absence. But I got about 2 minutes to get ready for my next meeting. The discussion's been robust. It's been a pleasure, and I look forward to continue working on this issue. Thank you.
Thank you, Judge Langdon. I believe Ms. Richardson, you're up next.
Thanks so much. So I'm just going to talk a little nerd to Brian real quick, and everyone else, but I know he's going to like it. Brian, I think 2 things. I think we want to look at the comments to the imputation rules 2 and 3, which really lay out what are the principles that we're looking at: loyalty, effectiveness, that type of stuff. And then I would also look at 5.7. We haven't spent a lot of time on that. I know we're focused on imputation, but I think it matters, because what you left out of what you were saying respectfully is there is going to be a disclosure there. And the disclosure, which the state bar could be part of crafting, and a lot of people on this call would be really good at this disclosure, including, here is the risk to you. It has to be informed consent to get the conflict, right? It could be, I mean, I am shortcutting this for purposes of time, but here's the problem that could happen. Because my partner owns this, I could have a conflict. You need to understand that. Do you understand that? And I know this is sophisticated stuff, but I do think the people of North Carolina, we allow them in life insurance to do that. And don't forget the adoption opinion, which again is an area I don't practice in, but one we have to look at, because if you look at the businesses there, they are very important. And I think the reason I'm bringing up 5.7 again is the question here is whether or not this is law related. And I had to go look at the law of lawyering. There is in fact a section there, 5.102. And in it, as an example of law related services, it uses title insurance like as its leading thing. And of course, that's not necessarily binding on North Carolina, but they write a lot. They know some things. So I just want to make sure we're really focusing in, as you are, on this imputation issues and those particular things and the rules. Consistently, we've said this personal interest, right? That it's not necessarily imputed, but if it is, there's those limitations. So sorry, that was quick, but I wanted to make sure I addressed those particular things you were talking about.
Thank you, Amy.
Right. I believe that, Craig, you have a comment, and of course, as a member of the committee, you're going to get precedence over everybody else.
Well, you're mighty kind. I have 2 things. One, Brian, I just want to grease the skids a little bit. I'd be interested in your take on the application of comment 2 to rule 1.10 to this fact pattern that we're dealing with. You don't need to answer right away. You may need to look at that and contemplate a little bit. And the second thing I wanted to mention is something that I'll kind of frame for Amy Hunt, just because of her unique position, but others can speak about it as well. And that is, I'd be very interested to know, anecdotally, how many title policies are typically issued in connection with a residential purchase that have just general exceptions in them, like all matters that would be shown on a current and accurate survey, or all matters of record, which to me doesn't really provide a whole lot of protection. Obviously, I'm a commercial practitioner. I deal with people who are very sophisticated, who will really kind of look very carefully at a commitment. And they really, in the commercial sense, have commitments that are very detailed, that no commercial client of mine would allow us to just say, well, this is a commitment that really just has an exception for matters of survey and matters of record. So anyway, I think that they're different, but Amy, you may be able to speak to that. I don't know. Others may be able to speak to it. But to me, that really doesn't afford very much protection for the consumer.
Mr. Patone, I believe you had your hand up again.
Yeah, I just wanted to make a couple comments in response to Brian's questions. Yes, you were correct in that attorneys are largely given the decision making on where title insurance goes, but as a practical matter in the current landscape, we see somewhere around 80% of our transactions come over with a directive of where the client would like us to send that title insurance, whether that be a realtor's captive title agency, a builder's captive title agency, a lender's captive title agency. So while much of the conversation has been around these like massive changes that would take effect if the decision came down one way or another, every attorney would still be in a situation where they're going to have to weigh the balance of, am I willing to disregard this client's request on where they want us to send this title insurance, and also risk um, hurting a referral relationship, right? So there are currently business relationships, referral relationships that we have to consider in determining where and how we send our title insurance business even today. And I don't think that would likely change dramatically in a world where the ethics opinion were to come down and say we could refer them to our own agencies. Those things are still going to exist. And number two, would somebody close on title with an issue? As Mr. Benson has pointed out in his thought leader memo, North Carolina has some of the lowest title insurance rates in the country currently. So I think the answer to that is probably no for the $700 to $1,200 that we would make in title premiums on a closing. The likelihood that we are going to just say, hey, that is so much money, it's worth taking a risk with major title issues, I don't think that impacts our decision making one iota. We're already on the hook for much of this anyway, in that if we make a mistake in our title search or our opinion, we're often paying out of pocket for it. It may not even make it to our E&O or to a litigator's desk. We're being asked to cover that before it even makes it to the point of a title claim, because we're often worried about being disapproved by this title company or that title company if we have too many actual claims submitted. So ultimately, just wanted to say that I don't believe that the small amounts, at least on residential deals, of those title premiums really are going to impact an attorney's ability to guide their client on whether or not they should or should not close with issues that are out there. None of us want that on our CV. Clients out there experiencing title issues because of a decision we made. So thank you.
Mr. Benson, since he recognized you, I'll go ahead and recognize you then. Mr. Linsky, I'll come back to you. I think you're next in line after that.
Thank you, Martin. Just a couple of things. One, just a couple of bullet points as people were talking. One is to Nathan's comment that somehow investors' title is leading the conversation here on behalf of kind of opposing change. That's totally inaccurate. I mean, we were approached by the leaders of the real estate bar to try to vocalize and articulate why the change is a terrible idea. And that partnership with the leadership of the real estate section has continued through now. I mean, you can demonize us all you want, but that's the way it is. I mean, and again, not to beat a dead horse, but the memo that we submitted last week was signed by the 24 leaders of the real estate section, or 24 of the real estate leader section, including Kyle and Malia. So, I mean, yes, we have a self-interest in this. It's nothing like what Nathan described. It's totally different than that, but there is a self-interest, but that doesn't mean that either we're leading the charge or that it's the current system is somehow inferior to change, because it's not. To the question that Craig asked about general exceptions versus specific exceptions, what we find generally is that in North Carolina, there are fewer general exceptions than we see in other states. And that is for all the reasons that we're talking about the two hats at the same time conflict that attorneys have. When an attorney is the title agent, that attorney has an incentive to make as much money off the policy as they can and to limit the coverage. So we do see problems like overcharging. And there was an example in the packet where Nathan overcharged his client by $1,200. We also see a lot more general exceptions in other states as compared to North Carolina. So we do see that as an issue. The comment about that was just made about North Carolina's rates. Yeah, we have the second lowest rates of title insurance in the country right now. Only Missouri is behind us. If the answers to any of these three questions is yes, that will stop. The whole financial system will flip on its head, and the rates will have to increase. So that will absolutely happen. And that is a harm to consumer, at least in my mind. That's a harm to consumer. You guys would have to decide that for yourself. So, and the last thing, the bullet point that you made about nerding out there a minute ago, Brian, and I can nerd out with the best of them. I do think you have to draw the distinction between the business, the related business that the financial product the attorney is selling, and decide whether 1.7 and 1.8 is appropriate, because 1.7 and 1.8 has a lot of language about the need for the client to understand the product, understand the waiver that they're signing. And I would suggest that things like accounting services, life insurance annuities, or whatever they're called, those are things that the average person has their head around pretty well. And if they don't, they can get outside advice. Title insurance, if there is ever going to be a product that is a difficult product for the consumer to understand and for a waiver to be inappropriate, it's title insurance. It is something that the average consumer, and Martin, you may disagree with your practice, you may agree, or Craig, the average consumer comes into your closing with very little understanding of title insurance. They are pretty much entirely reliant on the attorney. And I would suggest that in that kind of a product, a waiver is inappropriate because the client is just not going to know what they're waiving. It's just not something that is practical or something that's easy enough to understand in North Carolina. So apologize. Those are just kind of some bulleted points that I just wanted to respond to over the last few minutes worth of comments. Thank you.
All right, and so we're beginning to run short on time, but I have some folks that have had their hands up for a while, so I do want to recognize them, but please limit your responses as much as possible. Mr. Zielinski, I believe you're next, and then Mr. Rosario, and then Ms. Williams.
Thank you. As far as this allegation about the overcharging, that's just a baseless, false allegation. We obviously charge.
Mr. Zielinski, if we can we deal with substantive at this point?
Absolutely. So, Brian, you asked a question of whether whether the attorney having the title insurance agency affected the negotiations with the underwriter, and the answer is it does, to the benefit of the client. Because if you are an attorney and you have that interest in that title insurance agency, you have a business relationship with that underwriter. You're remitting money to that underwriter on a monthly basis. So that underwriter wants to keep you happy. Essentially, you can leverage that business relationship that you have with that underwriter to the advantage of the client. So it does, in fact, it doesn't create a conflict. It creates an ability for you to get enhanced and better coverages for your client. And the other question that you had asked is, does this create a financial, conflict that you want to close a deal because of the title insurance? The reality of real estate closing practice, and any closing attorney can tell you this, is that it doesn't matter how much money you make on one transaction. One transaction is not a closing practice. You have to have volume transactions and repeat business in order to stay in business and go ahead and have a successful closing practice. There is nothing that would happen in one transaction that any closing attorney would be willing to, like no title insurance premium or closing fee or even legal fees for that matter, that is worth it to them to jeopardize that, because they're always looking to think about, well, how much am I going to close next month? And I want to keep these clients happy. I want them to come back and refinance with me. I want the real estate agent to come back and use me on their next transaction. And so the idea that we would just sort of hurt the client to make a quick buck on one transaction is just not the reality of what we deal with in the closing industry. Lastly, let's not lose sight of the fact that somebody has to issue the title insurance. It has to get done, whether it's an attorney-owned title insurance agency or someone else. If it's attorney-owned, at least we have the ability to overlay the rules of the rules of professional conduct as opposed to a lay person. And ultimately, we have to think about what is better: rules of professional conduct with connection with title insurance, or no rules of professional conduct. And that is the fundamental choice. I would submit it's better for the consumers to have the protections of the rules of professional conduct. Thank you.
Mr. Rosario?
Thank you. I wanted to touch base on one of Brian's points from earlier when he was discussing a number of different conflicts, specifically with regards to situation that was articulated where someone is, let's take a residential purchase, for example, and it was brought up that it's a requirement to receive a mortgage, which is true, that a title insurance policy is issued guaranteeing the lien on the real property that's being transacted, that's being purchased. What I do want to highlight mechanically that I don't know that all members of the committee are aware of is that after the Dodd-Frank Wall Street Reform Act, after the 2008 financial crisis, there was a mandatory disclosure for all residential mortgages backed by Fannie Mae and Freddie Mac that owner's title insurance is notated with the word optional next to it. And what I want to make sure that everyone grasp about that is that the scenario of consumer harm that's being articulated consistently in this discussion is with regard to the situation where an attorney has agreed to represent a client and it's now issuing a policy guaranteeing their ownership, but yet that policy is disclosed as optional from the get-go. So the prospect that a consumer can't understand what they're actually buying when they have to make the determination if they want to buy it in the first place is preposterous, in my opinion. So in every single residential transaction, yes, there's a lender's policy of title insurance that's mandatory. That's not up for debate. But again, that doesn't really matter because that price is fixed and the coverage that's demanded is based on market forces, and there's no overcharging that's ever going to occur because the lender determines what coverage they want. The issue with regards to consumers being forced to potentially overcharging or the opportunity for a lawyer to essentially just make more money on a real estate transaction is simply misinformed. Because again, the disclosure of optional is given to every single consumer in a residential real estate transaction. So that's just a fact. I also wanted to touch base on another point that was made specifically by the underwriters throughout this discussion, and that's with regards to the two hats conflict that keeps being referenced. And I think that it's really important, as we've articulated in the rules, these conflicts seem to be waivable in so many instances, and arguably they are currently for the issuance of a title insurance policy. And I think what's really, I guess, enlightening or I guess perplexing from my point of view is that I can't understand, as someone who has an active underwriting contract in a number of states, how an attorney who is issuing a title insurance policy is somehow not going to adhere to the same standards that is required of a title insurance underwriter currently. And so we talk about standard exceptions and different items that may appear on a title policy or a title commitment. However, these items are not going to be, they're not going to change. The attorney is hired to close a transaction to represent the best interest of the buyer. And regardless of any other fact to the contrary, the attorney is going to abide by their client's best interests in conformity with the underwriting contract that they have from the title insurance underwriter, which is going to be no different than what the underwriter is already willing to do upon mutual negotiation. So I just want to make sure mechanically we're not inventing issues that don't actually exist, because the marketplace has been well established in all 49 other states, and this conflict really isn't an issue. If anything, consumers in North Carolina are deprived of better services because the title insurance underwriters have pushed a regime of tacking, which it results in attorneys barely searching title and not actually discovering defects that are often found through a full 30, 60-year search in the rest of the country. So those are just some points, and I appreciate just considering those thoughts. So thank you all.
Ms. Williams, you had your hand up, but I don't see it now. Are you still interested in speaking or not?
Yes, I am.
Please, ma'am.
To address a part of these things is, so one of the items that was noted was the directed business, which is something that we have to deal with and face every day. So I'm primarily a residential closing attorney. So when I get the purchase agreement in and then I get the title request, a lot of times it does come with a directed request for a certain either agency or group to be used that is either associated with the realtor or with the lender. 99.999% of the time, when I call the client and I say, did you have this discussion with your agent? What is it that you would like to do? Is this the company you actually prefer to use? They have no idea what they signed. they said that was just with the packet and they signed it and they have no preference. Because once again, as Amy had touched on earlier, it is muddy and it's simple and it's easy for a client to understand that, okay, my attorney has a financial interest in this. That concept is clear. That's an easy to understand issue. The problem is that with title, every single title review is different. Every single title issue is also different. We have a finite timeline with residential closings in particular, which is why I keep going back to that, where we are searching title. And to speak to the tacking on, if it is best practice, you are reviewing the prior title policy to make sure that it is actually done well and it's done correctly. A lot of what we do is gratefully on record. So there may be a prior policy that's in place and I will still do a full search and issue the prior policy with my opinion so that they get a rebate. But if there is a problem with the Schedule B and the exceptions that are shown, I review that in my search and I show that in my documentation. And there are exceptions to coverage that oftentimes I know need to be removed from the new issued policy that comes as a result for this next closing. So in light of that information too, the amount of disclosures that would actually need to be made for informed consent, there would be a disclosure at the beginning explaining point blank period what actually title insurance is and what it means. And then there would be an additional disclosure that would need to address all of the legalities of what title issues were found, whether or not the agency that is associated with that firm was willing to cover it, whether or not it was explored by another agency that they would, and whether or not they will still acquiesce to me using the associated agency. I mean, there's too many issues involved with that for them to be able to inform consent.
Thank you, Ms. Williams. It is a little past 3:17, and in respect for everyone's line, is there anyone else who wishes to speak, or can we go and close this down for now? If
Yeah,
not,
Martin, I feel like we could probably talk about this forever. And these are, and I gotta say, I really appreciate the thoughtful contributions that everybody has made. This is an issue that I understand gets a lot of different interests involved, but just from the ethical perspective, and yes, I appreciate the fellow nerds on this call, whether we're talking about law-related services, imputed conflicts, all this kind of stuff. I mean, ultimately, these rules, as part of an independent, self-regulating profession, we have to draft these rules for the benefit of those that we serve. And I think that's trying to, of course, it's also one of those things that doesn't necessarily mean that they have to be to the detriment of the profession too. But we do need to find out the best answer. And I really appreciate all the thoughtful commentary. I imagine that next steps, we will, of course, the ethics committee's next meeting is in October. I think we probably still need to have another subcommittee meeting at some point to start figuring out exactly what is to be said, if anything. So we'll reach out to the subcommittee members about availability, and I think that's where we'll stand. Martin, is there anything else you want us to address today?
no, I think that's it. I do not have control over the meeting, so Brian, you'll have to let us out.
I will let everybody out. I feel like it would also be I'd be remiss if I did not recognize that apparently there's some big news that occurred right before this meeting, and that's Taylor Swift is engaged to Travis Kelce. You're very happy. I can see a lot of you out there. So yes, congrats.
That's
Taylor,
a big thing to drop right at the end of a call like this.
right at the end of this conversation. Levity is always a good thing in these moments. So thank you all for joining us. I really